Welcome to the University of Michigan Dentistry Podcast Series, promoting oral health care worldwide.
Okay, let's see how we're doing. No sign of infection. The healing looks normal. I think we'll take a look at those stitches.
I haven't been able to taste anything. Is this the normal effect?
You can't taste anything at all?
Well, still, some taste. It's so bland, not as good. What's wrong?
Well, I'm not sure. When we perform surgery in that area of the mouth, there's always a chance of nerve damage.
Nerve damage? I didn't know that was a possibility.
Well, look, whenever we use anesthesia and do surgery, there's always a risk.
Well, don't you think you should have told me? I think I had a right to know that.
Well, look, I don't have the time to explain every detail of every procedure to every patient.
I had the right to know that.
I don't have the time to talk about this anymore.
Maybe I ought to discuss this with my attorney.
Malpractice, a growing threat to the practicing dentist. What is malpractice and how can you prevent it? That's our topic on this edition of By Design. The increasing complexity of dental practice, coupled with the rise in consumerism, have made the threat of a malpractice suit a reality for many dentists. Our guest today is Mr. Edward Goldman, staff attorney at the University of Michigan Medical Center. Mr. Goldman's responsibilities include counseling and defending healthcare workers, including dentists, who are sued for malpractice. Ed, has there been a rise in the past few years in the number of the dental malpractice cases?
Yeah, there has. As patients become more consumer-oriented and as the level of trust in dentists and other healthcare professionals, for that matter, seems to decrease, patients are becoming more conscious of their rights and more willing to bring lawsuits.
Okay, but let's back up for just a minute. How exactly would you define malpractice?
Malpractice is a fancy word for a civil wrong. It's something that everybody's familiar with in other contexts. For example, in an automobile case, a civil wrong simply means that you have a duty, that you've breached that duty, and that you have caused some damages. In an auto case, if you run a red light, you've got a duty to stop. You breached that duty by running the light. And if you ran into somebody walking across the street, you have caused them some damage. Now, malpractice is a word that means civil wrong as applied to professional responsibility suits, engineer suits, lawyer suits, dentist suits, and the same four standards, duty, breach of duty, causation, and damage, apply. The difference is that it's not as obvious to juries what duty and breach of duty means in a professional suit. They know that you're not supposed to run a red light, but they don't know the right way to extract a molar. So the four elements apply, but there needs to be more education in a professional case to explain to the judge or jury just what the duty was and how it was breached.
Okay, in terms of a standard of care of some sort.
Yeah, that's exactly what it is. The idea is, what standard would a professional use under these circumstances? What would a reasonable person do? And for a jury to understand how a reasonable dentist would operate, they have to have information about what the standard of care is.
Okay. What do patients sue for? Is it always for this breach of the standard of care?
Well, as I've explained the system, theoretically, they should only sue if there was a breach of the standard of care. In fact, that's true in about a third of the cases. At least 1/3 of the cases I've seen, the suit is because the patient is upset with the dentist. They don't like the treatment they received, they don't like the dentist, they don't like the dental assistant, any number of reasons. They don't like the amount of the bill, they're just unhappy for some reason. Something went wrong. Not necessarily a bad result or any malpractice, they're just mad. And they feel powerless, and the way they can try to get more power is they can sue. Another third of the cases, approximately, and these are rough figures, are cases where there's a bad result. Not necessarily any breach of the standard of care, but the result is not what the patient expected. Malocclusion of the jaw, It's fixed. The dentist fixed it in a professionally responsible manner, but the patient still doesn't think that they look good. And so they're upset, and they bring a lawsuit saying, this is not what I expected, it's not what I wanted, therefore you owe me some money. And the last third, approximately, are cases where there was some actual malpractice, some violation of the standard of care.
Okay, could you give us a few examples of some common cases?
Oh, the easiest kind of cases to understand are cases where there's some known procedure that is not done. Failure to sterilize a socket after extraction of a tooth. Injury due to the negligent use of an instrument. You drill through someone's tongue instead of their tooth. The cases I'm seeing more of are nerve damage cases, damage to the lingual nerve during extractions. We've got cases now where people say that they have a loss of taste after extraction of molars. The other kind of cases I'm seeing more of are cases where one dentist is practicing differently from other dentists in the community. The community sets the standard of care. For example, there's one case where multiple extraction case in Michigan, where 16 teeth are extracted at the same time. And the standard in the community is that you would never do more than 8 teeth at the same time. That case was compounded by the fact that the dentist didn't explain to the patient exactly what was going to go on and how many teeth were going to be removed. It was a situation where the dentist said, don't worry, I'll take care of everything. It would just worry you unnecessarily for me to explain what it is I'm going to do, and then went ahead and extracted 16 teeth, was sued because there was some damage and some pain afterward. And the other dentist in town had to say that the standard was 8 teeth, so the standard had been breached and the dentist was found liable.
Okay. What about a dentist working beyond their area of expertise? Can that lead to problems too?
Oh, certainly. And again, more cases are coming up now where a dentist does a procedure that the dentist isn't qualified by training, experience, or licensure to do. As you know, there are several subspecialty areas in dentistry, and you need a specific license to engage in those areas.
Okay, thank you. If a dentist is employing assistants and hygienists, is the dentist responsible for their malpractice as well?
Yeah, the responsibility goes like this. The employer is always responsible for the actions of the employee. It's an old law coming from, several hundred years ago in England. The theory was called a deep pocket theory. The notion was the employer had more money than the employee, so if the employee does something wrong, the person who was injured is allowed to sue the employer because it's more likely that they can have a monetary recovery.
Dentists use a lot of equipment and products in their practice. Are they responsible for these as well?
Well, they're responsible in the sense that they have to use them correctly. But there's someone else who's responsible, and that would be the manufacturer. If you do a procedure and a drill breaks off in a patient's mouth, that could be because you were exerting too much pressure or using the machinery improperly, or it could be that the drill was manufactured improperly. That's an area of the law called products liability. In a case where the product is defectively manufactured, the responsibility would lie with the manufacturer rather than the user. Now, as an evidentiary matter, if anything like that happens, you have to be able to prove that there was a fault in the drill. So it's important for the dentist to save the pieces so that they can be analyzed to see if there was a stress fracture of the metal or metal fatigue or some other improper manufacture problem. All too often, what a dentist will do is throw the pieces away and then attempt to claim that the manufacturer was improper and not have the evidence to prove it.
So he should maybe just keep these pieces in a little envelope and put it right in with the file?
I would keep them in an envelope and label the envelope. Pieces of drill broken on January 1st, 1980 during procedure on patient so-and-so.
Okay. If a dentist aggravates a pre-existing condition in a patient, is the dentist then liable for that problem?
It depends in part on how the history was obtained. If the dentist took an adequate history and the patient was simply a bad reporter, the dentist, for example, said, "Do you have any allergies?" And the patient said, "No, absolutely not." "Are you allergic to any anesthetic agents?" "Oh, no, I've had anesthetic before, there've never been any problems." And the dentist gives anesthetic, the patient has a bad reaction. In that case, the dentist would probably not be liable because in addition to the four elements, the duty, breach of duty, causation, and damages, the patient also has some responsibility. And that responsibility is to be free of negligence on the part of the patient. So if the patient reported improperly, the dentist would have an argument about why the dentist wasn't liable. On the other hand, if the dentist took an inadequate history, failed to ask questions about allergic reactions, and then gave anesthetic, and there was a bad result, the dentist would probably be liable. Equally, if the dentist doesn't have adequate procedures, the dentist could be liable. There's a fairly recent case where a dentist gives general anesthetic. In Michigan, you're supposed to have a year of training and experience in anesthetic before you use general anesthetic. Dentist went ahead and gave general anesthetic, didn't have a crash cart available, had not taken an adequate history from the patient. Patient went into shock. Dentist had no way to handle that situation, and the patient ultimately died. And the dentist was held liable both because the dentist had failed to take an adequate history and discover the pre-existing condition, and because he didn't have adequate backup in his office.
If a dentist were doing just a simple amalgam restoration, would they still need to, would you recommend that they still take a complete history, or should they do this with all new patients, or?
I think it's helpful for two reasons, one legal and one non-legal. The legal reason is in some, perhaps small percentage of the cases, you're going to find an anomaly. You're going to find an allergic reaction or a pre-existing problem or a problem with the patient's jaw, or patient has undergone recent surgery, something like that, that it'll be important for you to know about. Second, non-legal, as a public relations matter, to the extent that you can build trust with the patient, get the patient to think that you're acting as a competent professional, that you're interested in them, interested enough to take a history, they're less likely to sue. As I said before, about a third of the cases are because the patient was upset. Anything you can do to lessen that upset lessens the chance of a lawsuit.
I can see that this might be a problem in giving advice over the phone.
Giving advice over the phone is a terrible problem in any of the healthcare professions. You can't diagnose very well over the phone. You're taking the patient's history at face value without the ability to observe and check, and we know that sometimes patients aren't very good reporters, and there are a number of suits where people get into serious difficulty giving advice over the phone without any ability to follow it up. My feeling is the best advice you can give over the phone is, "I'm sorry, I can't give you any advice over the phone, but I can see you this afternoon at 3 o'clock.
As this might be difficult with friends, I would think, of the dentist.
Oh, it's very difficult with friends. What happens in the cases of friends, everybody's more casual about it. You don't take good histories, you give advice over the phone, and because it's your friend, you tend to minimize the importance of events. Friend says, "My tooth hurts," and you say, "Oh, well, you know, it'll probably get better." And you can quickly lose friends when it turns out that you have misdiagnosed in this casual fashion.
Dental procedures require close physical contact with the patient. Are there cases of indecent liberties?
Yeah, there are some. Generally, they come about where the dentist may or may not have done anything wrong, but thinks that he's doing a favor for the patient. Patient says, "I can't come in during normal working hours." Dentist says, "Well, I'll see you after hours." Assume the dentist is a male, the patient is female. Patient comes in after hours. There is no third party present. Generally, the dental assistant or the hygienist or receptionist would be there, but this is after hours, so nobody's there. You've got a situation that's just ripe for a lawsuit. It will always be the word of the dentist against the word of the patient. And it's a situation that can be avoided by not doing procedures after hours.
Or having a third party present.
Or having a third party present if you're going to do it, that's right.
Can a dentist discuss a patient's case with another dentist? Is this a breach of confidentiality?
Well, confidentiality rules are set forth by state law, and they say that there is a dentist-patient privilege. That privilege is owned by the patient, so that you cannot reveal any information you have about a patient to a third party without the consent of the patient. Now, there are times when you'll need to do a consult, and you can do that, but you should be careful not to mention the patient's name or give identifying information, except if you have the consent of the patient first. The best practice is to say, I have looked at the problem, I think I'd like to consult a fellow professional about this. Is that all right with you? The patient invariably says, sure, that's fine. One or two cases, what you'll get is a patient saying, that's fine, except I would appreciate it if you didn't consult Dr. So-and-so because he's my next-door neighbor, or in one funny case out of the state of Michigan, he's my former husband and I wouldn't want him to know. So those are reasons for telling the patient in advance what you're going to do and get consent. And again, the reason that I've talked about a couple times already, the question of getting the patient's trust and getting the patient working with you so that the patient respects you. All the more reason to tell the patient in advance what you're going to do.
Is there a statute of limitations concerning malpractice cases?
Oh yeah, and the statute of limitations simply means how long you have to bring a lawsuit. In Michigan, the statute says you have 2 years from the end of treatment to bring a lawsuit. If you wait 1 day after the 2 years, too late, and the court will not hear your case. Michigan statute goes on to say you have 6 months to bring a case for previously undiscovered problems, even after the 2 years has expired. That's important for surgeons if they leave a sponge inside someone or leave a piece of a drill inside. But for the most part, for general dentistry, the statute is the 2-year period, and nobody worries about the 6 months for undiscovered problems. That's for adults. For children, the rule is that they have 1 year after they become an adult to bring a lawsuit. So in Michigan, you're a legal adult at age 18. Child would have until age 19 to bring a lawsuit.
We'll be back to discuss how to prevent malpractice after this management fact. We've been talking about malpractice with Mr. Edward Goldman, staff attorney at the University of Michigan Medical Center. Ed, what can a dentist do to prevent malpractice? Could you list a few do's and don'ts?
Sure. I've just jotted down a couple of ideas here. There are really several areas to look at. The first is to use the referral system. Don't do work out of your area of expertise. There's a problem that you aren't absolutely sure you're capable of handling. Referral is always the best way to go about it. There are too many suits now of people who are just doing specialty procedures and not doing them properly. I think a second area would be making sure that your equipment is adequate and up to date.
And maintaining the equipment.
Maintaining it is very important, having a preventative maintenance program. Otherwise, the equipment can break down, and you've got responsibility. May be shared with the manufacturer, but if you have not had a preventive maintenance program, it's probably your responsibility. The question of taking a good history from the patient, something we discussed earlier, is very important. Avoiding advice over the telephone is something that avoids lawsuits. One area recently that's come up is the question of coverage while on vacation. It's important to have the coverage, and it's even more important to be sure that the coverage is adequate. For example, if I were to say to you, I'm going to be going on vacation next week, I'd like you to just take over for me next week and I'll do the same for you one day, that's not going to be enough to protect me from a lawsuit. What I need to do is explain to you about any problems that are going to come up during the week. For example, I've just extracted several teeth from Mr. Jones, and I'm worried about complications. There's a possibility of an infection problem. So that if Mr. Jones comes in, you know who he is and what the problem is.
And put that in writing too?
I think it's helpful to either sit down and go over the records or perhaps just do a summary of some of the most important cases so that you could have that. You could have information right there at your fingertips. So that would, it would be helpful to know. And then you can avoid the problems when Mr. Jones comes in or whatever else. Continuing education is another area that's very important for dentists. It's important both to keep your level of skills up and also because it's persuasive to a jury. If you get sued and you can say to a jury, I just had training on that. I had 40 hours of update on that particular procedure. The jury understands that you've had recent experience and they're less likely to find that you had done anything wrong. The question of guaranteeing results is another area. That's certainly a don't. A guarantee of results can only get you into trouble. If I say there will be absolutely no problem with this procedure, and then there is a problem, the patient is upset, there's more of a reason for the patient to sue.
Yeah, I can see that.
The three big areas are a good relationship with the patient, good medical records, and informed consent. And we ought to spend a little bit of time on those. There have been several studies done, and the major conclusion of the studies are that patients who like you tend not to sue you. So establishing a good relationship with the patient, apart from the legal reasons for doing it, minimizes the possibility of a lawsuit.
And being honest with them when any problems occur during procedures?
I think so. One of the findings of the studies has been that if you tell somebody a problem occurred, they're less likely to sue you, especially if you tell them in a professionally responsible manner. The bit of the drill broke off, but I found it. I've extracted it. Here, you can see the first x-ray. You see this little line here? That's where the bit is. And here's the second x-ray showing that the drill is gone so that we know it's out of your mouth and there's not going to be any problem. It hasn't caused any complications. There was no bleeding. There were no other problems. And I just wanted you to understand what happened. That kind of thing can avoid the lawsuit. Whereas if you say everything went fine and later they find out that the drill broke, they can be afraid that you're not telling them the truth.
They might think, well, what else might
What
have
else
happened?
happened? That's right. The question of records, medical records, is very important. Good records win lawsuits. What the jury thinks is, if you wrote it down, it happened. If you didn't write it down, it didn't happen. You can say, I know I did the procedure, I know I did everything right because I always do it that way, but if you don't have any record, it's easy for a jury to say, well, you're making that up. You've been sued, and now you're trying to say that you did everything right. But if you'd really done everything right, you would have had it written down.
Just jot it down on the patient record.
Sure. And the question of consent is another one that is very important, interrelated with the question of good records. You started out by saying that this is an age of consumerism, and I think that's right. And we're having more and more lawsuits now where the patient says, the dentist didn't tell me what the procedure was going to be. If I had known that extraction of molars could lead to nerve damage, I never would have consented to the procedure. The idea behind informed consent is that you tell the patient what the procedure is all about, what the risks are, what the benefits are, what the alternatives to the procedure are. And if you do that, and you allow time for the patient to ask questions and become fully informed about the procedure, then the patient is informed. Now, what difference does that make? Well, legally, if the patient is informed, they cannot later sue you for saying, I never would have consented if I had known. And they can't sue you for a result that they knew might have occurred, a bad result. You say to them, in some of these cases, there will be discomfort for a period of time, or there's a distinct possibility of infection in a case like this, and I want you to be aware of that in advance. Patient says, well, go ahead, I understand that. And later on there is an infection. The patient can't bring a successful lawsuit because they've been warned and they've accepted the possibility of that result.
Should the dentist have the patient sign something, a form, or is verbal?
For routine procedures, I don't think you need a form. For more involved procedures, I think it's helpful. The form is not the informed consent itself. The form is just a documentation. You can produce it in court 2 years later and say, look, there's the patient's signature. Isn't it true that you signed this? And I have listed the procedure and the risks of the procedure. So you were aware of those, weren't you, patient? You can't deny that because there's your signature on the paper. That's what the form is good for.
Okay. What can a dentist do if he is involved in a malpractice suit and he thinks it's simply a harassment? He thinks that the suit has no basis. Can the dentist countersue?
That's an area that's been getting increasing attention. The courts have uniformly been saying that countersuits are not valid except if there is what is called in the law malicious prosecution. The patient brought the suit just to, for no good purposes at all, but just to harass the dentist. Very few suits are really straight-out harassment suits like that. There's usually some reason, a bad result, an unpleasant incident. It may not be malpractice, but there's some logical reason to bring the suit. The courts have been saying that countersuits are not good because it puts too much of a burden on the system. In other words, if the patient says, well, if I sue the dentist and I'm not successful, then the dentist might sue me. It's a what the law calls a chilling effect on your right to bring a lawsuit. And again, it's a consumer-oriented age. The tendency is to protect the consumer and not the dispenser. And so the courts have been striking down those kind of countersuits. Now, if there is a suit that just has no merit, the best defense is to bring out the facts as early as possible in the suit to show that the patient does not have any suit, so that the attorney for the patient understands that it's going to be a waste of the attorney's time, and oftentimes suits can be dismissed at that level. If the doctor hides the facts, then the plaintiff's attorney doesn't know that there's a problem with the suit, and the suit goes on.
What would you recommend concerning malpractice insurance? Are there things that the dentist should look for in a policy?
I think so. The insurance question, the first question that has to be asked is whether you should have insurance at all. Some healthcare professionals are now saying, well, I won't have any, and then when somebody sues me, I'll simply say to them, I don't have any insurance, so you'll never be able to collect. If you get a judgment, you've got 10 years to collect it, and they can garnish wages or salary up to about 30% in Michigan. So it's not a wise choice to dispense with insurance. So assuming that you've made the decision to buy insurance, the question is what kind should you buy? There are a couple things to look for. First is that the policy will cover you for events that occur during the time of the policy. Let's see, there are two kinds of policies. One is claims made and the other is per occurrence. Claims made says you have to have insurance in effect the year the claim is made. Per occurrence says if you had insurance in effect when the event occurred, you're covered. Let me give you an example so you can see how that's important. If you are doing dentistry for children, I said before that the statute of limitations is 1 year after the age of majority. You do something on a 5-year-old. That means they have, what, 14 years to sue. Prior to 14 years, you retire, and so you don't keep your insurance up because you're retired from dentistry. If you had a claims-made policy and that child sued, you wouldn't be covered because your insurance wasn't in effect at the time of coverage. If you had a per-occurrence policy, even though you had not been insured for the past several years, you would still be covered. So per-occurrence is an important thing. The amount, of course, is important. You have to have an adequate level. In this day and age, I think $1 million is a minimum level. And anything lower than that is just too low. And the other thing I would look for is a policy that says the insurance company cannot settle the case without your consent, so that the insurance company can't settle a case out from under you.
What about the auxiliaries or hygienists that would be in the dentist's office? Would the policies, his policy or the dentist's policy, cover them?
Good point.
Well,
they should be covered by the dentist's policy, for the reason we talked about earlier. They are employees of the dentist, but it's important to report to the insurance company who they are, and there might be an additional premium charge for that.
Okay. What if, despite all the precautions, the dentist is sued for malpractice? What would you recommend to make things come out as favorable as possible for him?
Well, the first thing is to notify the insurance company immediately, and they will assign an attorney, talk to the attorney, review the records. A critical area is don't change records. I've seen too many suits where there wasn't any malpractice, but the dentist says, boy, I've gotten sued, I'll just go over my records and add a couple of things that I know I did. That's disastrous. The final thing, and let me just refer to my little list again for a second, make sure that the records are retained. Too often dentists clean out their office and throw out records. Again, problem with the child, if you throw out records every 5 years, you're not going to have the record when there's a lawsuit.
Right.
And the final thing, one thing our parents told us is absolutely right. Never talk to strangers. If somebody calls you about the case and it's not your insurance company or your attorney, don't talk to them.
Should you talk to the patient?
I don't think it's a wise idea generally. The patient has sued you, the patient has an attorney, and at that point, I think you can get into real trouble. You call up the patient and say, well, why are you suing me? You've always been my friend. I think it's not good advice.
Thanks, Ed, for this advice on malpractice. Our guest today has been Mr. Edward Goldman, staff attorney at the Medical Center of the University of Michigan. Join us again as we explore other aspects of the efficient management of a modern dental practice on future editions of By Design.
You've been listening to a presentation from the University of Michigan School of Dentistry, which is dedicated to supporting open learning and open educational resources. This recording is licensed under the Creative Commons. It may be reused and redistributed for nonprofit use. Please attribute materials to the University of Michigan School of Dentistry and redistribute under this same license. For more information on how this and other University of Michigan School of Dentistry recordings may be used, visit www.dent.umich.edu/license.